Please look up at the monitor. Here in the Spalding County State Court, we believe that each and every one of you, as you interact with this court, are entitled to the inherent human dignity that you wish for someone you care about. We'll extend that to each and every one of you as we interact with you all here today. Hey, don't talk during court. So our goal is to move your case forward and frankly get you back to your lives as quickly as we can. Can't do that if y'all are having sidebar conversations, and frankly, I won't have any patience for it. So don't talk during court and let us get you back to your lives. All right. I don't have anyone virtual, although I did get a note that someone was virtual, but they weren't here when I logged in, so we'll figure that out. Okay, cell phones. So everybody has pet peeves in life. Mine is cell phones ringing in the courtroom. I'm giving you fair notice that I'm unreasonably frustrated with cell phones in the courtroom, so here's my rule. Hey, take it out of wherever you've stashed it right now and turn it off. If you are ignoring me and your phone rings after this moment, you have voluntarily stepped into my pet peeve. Do not voluntarily step into my pet peeve. Turn it off. Don't let it ring. We don't have contempt here. Okay, so we've now established that I'm firmly human and I'm going to respond in an unreasonable manner to your cell phone ringing. Okay, this is your courtroom. If you were arrested here in Spalding County for a misdemeanor, you appeared or waived for your arraignment date, and you requested a trial. There's multiple floors of court one. I think Judge Coker has criminal going upstairs.
On four.
On four?
Yes.
So if this does not sound correct, step into the hallway, show your paperwork to the bailiffs, and they will point you in the right direction. Today is what's called your calendar call. I'm going to go over your rights with you, and I'm going to tell you what your options are, and then you or your attorney is going to tell me what to do with your case. Now, you may have a trial. There are two types of trials. There's a jury trial where 6 jurors sit in that box over there and issue a verdict on your case. And then there's a bench trial. That's where I make the guilt or innocence decision without a jury. Now, you may have a conference with the solicitor's office if you're representing yourself. That's this group up here to your left. And then you can ask me about an attorney, and we'll have, frankly, an awkward conversation about why you didn't apply at your arraignment date. But we'll sort that out. All right. Ms. Karen is here from our Veterans and Mental Health Court. So here's how this works. If you are a current member of our military or a military veteran, or you have a mental health diagnosis and you want a dismissal on your case, then if you're representing yourself, speak with Ms. Karen at the first break. Or if you miss a chance to talk to her, you can ask for a conference and speak with the solicitor's office, and they can help you figure out if you are a candidate for the program. If you're represented by an attorney, simply speak with your attorney. They are very familiar with the program, and they can answer any questions you may have. All right, your charges in this courtroom are misdemeanors. The average misdemeanor carries a maximum punishment of 12 months to serve in the Spalding County Jail and or a $1,000 fine. You can also, a few minor traffic charges like seatbelt have a lower maximum fine, and a few high and aggravated misdemeanors have up to a $5,000 maximum fine. Now, each of you here have the right to a speedy and public jury trial, where 6 citizens of Spalding County decide guilt or innocence on each of your charges. You can also choose a bench trial. Again, that's where I make the guilt or innocence decision without a jury present. You may waive your right to a trial and close your case with a plea if you choose. I have no preference. You must knowingly, voluntarily, and intelligently choose for yourself. You have the right to be presumed innocent, to force the state to prove your guilt beyond a reasonable doubt, to cross-examine the state's witnesses, to subpoena your own witnesses and evidence to court. You have the right to testify or not testify. You have the right not to incriminate yourself. And if you choose to remain silent, your silence cannot be held against you. You still have the right to an attorney. You may hire your own attorney if you so choose. However, if you cannot afford an attorney, then you should have applied on your arraignment date, like I asked you to, with the Public Defender's Office. I warned you at your arraignment date that if you did not take action ASAP, you would very likely waive the right to apply with their services. All right, an attorney would help you understand our criminal justice system, would explain what your charges are and what the defenses are to those charges, file motions on your behalf, engage in plea negotiations, subpoena witnesses and evidence for your defense, conduct a trial on your behalf and make objections, protect your record and appeal a conviction, and otherwise work to protect you. All right, first offender and conditional discharge. These each allow you to enter a plea without being convicted. However, you only get one of each for your entire life. First offender is for everything but traffic-related charges, so no DUIs. And then conditional discharge is for drug-related charges only. All right, no-load contendere and traffic charges. A no-load plea, which is what we call this for short, is where you enter a guilty plea without admitting guilt, and this is available on most traffic charges, no DUIs. You get one no-load every 5 years, and that's measured from the incident date to use date, ticket date to ticket date. A no-load will usually prevent points. It will usually save your license. It will not help you much at all if you're under 21. All right, if you're here today and you're not a U.S. citizen, you need to know that any conviction will very likely have a negative impact on your immigration status. There are several of you in this courtroom who are charged with family violence charges. It's in the title of your charge. If you are convicted of that family violence charge, you need to know that you'll lose any Georgia weapons carry permit you may have. Federal law will step in and say that you may never again possess a firearm or ammunition. All right, habeas corpus, weird old law that I'm responsible for explaining to you. If you're convicted, you may sue Spalding County civilly in Superior Court to challenge your conviction. Now, all traffic charges have a 6-month window to use your habeas rights, and everything else has a 12-month window in this courtroom to use those habeas rights before they expire. All right, you may conference today with the solicitor's office. If you're representing yourself and that's what you want to do, you'll announce conference when your name is called. You'll remain here in the courtroom. Now, I'll remind you again, the solicitor's office, this group up here to your left, they represent the state of Georgia. They're not your attorney. If you reach an agreement with them, you can resolve your case. If you do not reach an agreement, this is very important, you must return to this courtroom for me to personally give you your next set of instructions, which will include signing the verdict form. Okay, if you decide to enter a plea and you receive probation, you need to know that you will be supervised by the newly created Spalding County Sentence Enforcement. There's a one-time $25 intake fee that will be added to your case. And then 100% of all fines may be worked off with community service work at a rate of $10 per hour. Additionally, there is a $50 per month supervision fee each month that you're on probation. Now, that supervision fee is mandatory, but it can be waived after a separate hearing before me. Now, this is a 2-week trial calendar, so you need to plan ahead. All the trials, bench and jury, are together on this 2-week trial calendar. This is week 1 with your calendar call. We actually have a group of y'all coming in today, tomorrow, and another group on Wednesday. Then you all are going to skip a week while we all get ready for trial. And then in week 2, the jury trials and bench trials will begin Monday at 9 a.m. sharp, which would be the 28th, I believe. Yeah. So you'll appear each and every day as directed until your case is resolved. We will use two or three courtrooms in week 2, and we will reach your case for trial. All right, you want to help your friends and family. We're a small enough community where everybody knows somebody who knows somebody. So here's the deal. If you hear a bench warrant that's going to be issued for a defendant who's failed to appear, and you know that person, call them on a break, tell them to get down here ASAP, and you will definitely save them a great deal of future trouble. All right, pre-trials, speedy trial demands, that kind of thing. You must let me know if there's any sort of outstanding pretrial motions, speedy trial demands, or anything else that I need to factor into the scheduling of your case for trial. If you do not give this information to me in your announcement, or if there's a bench warrant issued, then you are waiving those pretrial matters. All pretrial matters must be heard on the first calendar, or they are waived, unless I specifically preserve them on the record in open court. All right, so this is important. I've had a lot of titles for this one, but this one just seemed to be the most appropriate. So here we go. If you announce this morning jury trial or bench trial, what you're telling me is the following. You do not want a conference. You do not want an attorney. You do not want a continuance. You do not wish to enter a negotiated plea. You do not have any motions that need to be heard, and you're ready to go because calendar call is your last opportunity to explore any of these options. I have zero intentions of discussing any of these options when your case is called for trial and the jury is standing outside those doors. That's the whole purpose of calendar call. Okay. When I call the calendar and you hear your name called, if you're able, stand up. That way you can see who is here. If you can't stand up, raise your hand high and get my attention. I just need to see you as I call your name. If you have an attorney, remain silent. Many of you are here represented by the Public Defender's Office. Let them announce for you, and we'll go from there. If you do not have an attorney, if you're representing yourself, then you're going to announce very loudly one of the following. So you'll yell out a lot louder than you think you need to: jury trial, or bench trial, or conference, or attorney, and then are there any motions? All right, with that said, let's jump in. Yeah, who's in jail?
Let's see, page 2. John Spalding Cook, got 3 cases.
Okay, see him this afternoon.
And we got page 7 and 9. Kenneth White, very bottom. And he's also got another one on page 8.
He's got the third one too.
He's got another one.
23 SR 516.
23 SR 516.
That's
That one, Mr. Moore.
Yes, sir.
Good.
That's it.
All right, and that's it for this calendar. All right, let's jump in then. All right, I see that the first name, Roger Anthony, is Mr. Singleton's.
They'll be here tomorrow.
Tomorrow, that's great. And again, I appreciate, Mr. Shepherd, you and your office managing that. All right, so 8:15. All right, Andrew Bosham, also 8:15.
Tomorrow.
Okay. Jacqueline Burney. Conference, thank you. All right, over to you, Mr. Malloy. Sharon Blue.
Conference room.
All right, thank you. You're good, thank you, Ms. Blue. All right, back to you, Mr. Malloy. James Boyd.
Conference room.
All right, thank you, Mr. Boyd. Thank you, Mr. Malloy. Okay, he's got 2 cases. All right, Mr. Malloy. Corey Brown.
Conference room.
All right, thank you, Mr. Brown. Thank you, Mr. Malloy. All right, Anthony Buff.
That's for bond forfeiture event.
And
Mr. Buck has the second case judge. It's getting right.
Okay.
But the case number I'm talking about.
all right, I'm gonna mark. Well, it's already a do not reset. So, okay. Well, but thanks for letting me know there's another case. All right, Patience Caldwell.
Conference room.
Conference.
They're good. They got it. Thank you. All right, Cook's in jail. See him Wednesday afternoon. Bianca Duncan.
Conference.
Conference. Thank you. Richie Emery.
Conference room. That's our case.
Y'all picked him up.
Yes.
All right, thank you. All right, I'm adding y'all and putting you down for a conference. All right, back to you, Mr. Malloy. Quentin Fennell.
Yeah, and I have a note that he's in the Cobb County Jail.
That's what we think also.
Okay.
We'll ask for a bench warrant, but no bond forfeiture.
Okay, that's a good solution. So bench warrant issued, no bond forfeiture. You said to Cal, Mr. Cal's.
We think you can.
That's fine. Like I said, there's no harm in this system. It seems to work pretty well for us. Okay. It doesn't look like it's family violence. Okay. Paul Harris. No,
As for bond forfeiture and bench warrant.
granted. All right, Mr. Malloy. Dewan Helms. Hold on a second.
Bench warrant on that. Well, that was resolved this morning.
All right, let's put that down for conference now. The individual that I got an email that said was virtual, but is not here, is it an IDOM, the next one. So,
Did he have permission to be virtual?
well, I hadn't gotten that far, so I'm gonna put a question mark next to it for now.
He's ours, Judge.
Yeah, so I'm gonna put it down for a conference, and Mr. Shepherd, I am gonna look into that. And he was here, but he disappeared, so the answer is yes. Okay, so the answer is yes, he did have permission, so. Anyway, so y'all talk, and if he jumps back in, I'll just get his phone number and then.
Yes, sir.
Like I said, he was clearly here on time. It gave me the notice that he was. Stephanie Johnson, that's you, Mr. Malloy. Johnson, she's here.
Conference room.
Shaquavian Keaton. Thank you. do it. Hey, this is the one that, Ms. Miller asked for leave on.
So we've got a resolution on it.
Oh, you do?
I don't know, sorry to cut you off, but I think I can shorten
Is your
this.
resolution on my resolution?
She does have a leave for next week, but since this is a multi-week calendar, she's gonna bring Mr. Kendrick in on the 28th to enter the week.
Right. Yeah, I was ready for this one to see a resolution. Okay, back to you, Mr. Malloy. Shade, Lane? Lane? No response?
That's for bond forfeiture and benchmark.
Granted. All right, back to you, Mr. Malloy. Jeremy Comte?
Carpenter.
All right, you're good. Thank you, Mr. Comte. Y'all let your attorneys answer for you, please. I have the best public defender's office in the state of Georgia. Let them do their jobs. Willie McMichael? Willie McMichael?
That's for bond forfeiture and benchmark.
Granted. All right, back to you, Mr. Malloy. Anna Mobley?
Your Honor, she's present in the hallway. She's gonna be a pretrial diversion. I was waiting for the probation to show up to give her the paperwork.
Okay, and I saw Officer Ellis.
Yeah, she just put her head in.
Okay.
That's already written up, Judge?
Yes. I just need to turn it in.
That sounds great. Carrie, you want the bailiff's walker out, or do you want to talk to her?
She's just in out in the hallway, Judge. Once I give them the paperwork, she'll be taken care of from there.
Sounds great. All right, Carrie Overton? It's not yours. Overton?
That's for bond forfeiture and benchmark.
Granted. Okay, all right, we need to talk about this one just a bit. So Benny Page is here. That's you. Mr. Moody filed a motion to withdraw. I believe Mr. Page is agreeing to that. Is that correct?
Well, I just found out about it this morning, so I was gonna ask the court, could I get a continuance to have me an attorney?
Okay, but I'm asking about Mr. Moody representing. Do you want Mr. Moody to stay on your case, or do you want him to be allowed to withdraw from your case?
Stay.
Okay, well then we'll need to have a hearing on it. He's upstairs, and we'll need to sit tight. You need to sit tight, because I'm gonna need to hear from Mr. Moody on this one.
Just a second, we have this. Yeah, just that one.
This is the, you're junior, senior, third?
Zoe,
Junior.
well, sir, could I?
We're gonna have a whole hearing with you. I needed to know enough to know which way to do it. So if y'all, whoever's upstairs, somebody let Mr. Moody know that I need to see him before he leaves the building.
Benny Page. We have some people usually respond to that. Brad, you may.
All right, Mr. Page has two cases. Again, we'll address those. Piper's gone upstairs to let Mr. Moody know. And Mr. Hope has informed me that he had contact with Mr. Moody and informed him to be here today so we could address this question. So this should not catch Mr. Moody off guard. I just couldn't find a conflict letter. Do y'all have one by any chance from Mr. Moody?
I don't recall seeing one, Judge. I don't want to say no.
Well, I don't recall seeing one. That's the best I can say as
I
well.
remember the motion to.
Yeah, that's the,
withdraw.
thing.
I was expecting it here. All right, back to the calendar. Betty Hayden.
Carpenter.
All right.
You can do that.
Yeah, we'll just.
All right, that's page 5. All right, Mr. Hutchison, Christopher Pemberton.
So Judge, those are tomorrow.
Okay.
He had something pop up he's got to resolve this morning, but all of his clients are coming tomorrow.
Okay, tomorrow's great. Appreciate y'all. I appreciate y'all communicating and getting that organized.
Yes, sir.
All right, Carrie Pilkington.
Yes.
Let's you, Mr. Malloy. Pilkington.
That's for bond forfeiture and benchmark.
Bobby Sanford. Sanford.
That's for
She's in the hallway, she's late.
Late. Okay. The warrant is granted. Just use your warrant. I'll deal with it in a minute. Sydney Stanley? Sydney Stanley? No,
How about that?
I thought so.
I will ask for bond forfeiture and bench warrant.
All right, back to you, Mr. Malloy. Roderick Stargell. Looks like two cases.
Conference, Your Honor.
Next one's yours as well, Story. Oh, I see.
Conference, Your Honor.
She's in the hallway.
She's in the hallway. She's co-defendant with Mr. Boyd.
Edgar Vines.
Conference, Your Honor.
Oh, you picked him up. Okay, on both.
Yes, Your Honor.
Got it. All right, Lindsay Ward. All right, thank you. Bonzo White. White.
Ask for bond
He's in the
forfeiture.
hallway, you know.
Okay. The
He's,
warrant.
he was on the conference.
All right, the warrant's late. Was he late or is he just in the
He was
hall?
on time.
Okay.
I'll withdraw the request for warrant.
All right, you're not missing this. Kenneth White's in jail, see him on Wednesday afternoon. All right, Courtney Wilkins. Wilkins? No?
Ask for bond forfeiture and bench warrant.
Granted. All right, back to you, Mr. Malloy. Willis?
Conference, Your Honor.
Okay. All right, Michael Wilson will be tomorrow.
Yes, sir.
Virgil Brown's office. Sounds great. Yarborough is here, I think, but your attorney's running just a minute late, so just sit tight. As for the attorney, called ahead and said, I should have a conference.
Yes, we're good to go, Judge. And that's she's already entered accountability court, so she'll be entering a plea this morning,
That sounds, yes.
and we'll be suspending this.
All right, happy to do it. So, I thought you looked familiar. Welcome to the accountability court. Okay. Aaron Young, Aaron Jamel Young, Mr. Warner. Young?
We'll ask for bond forfeiture and bench warrant.
Okay.
And there's the second case for Mr. Young, it's
Yeah.
disorder of conduct.
What's the case number? If you have it.
Yeah, we'll have it ready to roll.
So you said disorderly conduct?
Yes.
It was case number, do y'all know it offhand?
It
Okay.
hasn't found yet.
Oh, okay, got it.
I'll grab it.
No, that's not true. Okay, so, let me make certain that I don't have anybody virtual. No, I still don't. Okay, so, is there anybody here who is a witness who is subpoenaed to be here? Any witnesses who are subpoenaed to be here? All right, that's a no. If your name was here and your name, if you're here and your name was not called, if you're here and your name was not called, stand up for me. There's always a couple. It's okay, don't panic. What were you?
Yeah, that's Cameron Chastain, Your Honor, should be entering a pretrial.
Okay.
She's not even on any of the calendars for this week.
Oh,
It has the case, the accusation was filed this morning.
okay, that's not good. Let me know what you need.
Yes, sir.
All right, so she's good. Anybody else? Wow, all right. Don't get a lot of those. Ms. Shepherd,
No,
no,
we
we
did. Yeah, we did. All right, thank you, Judge. All right, good morning, y'all. I'm Patrick Shepard. I'm the solicitor. I'll be the one doing the conferences this morning. If you have an attorney, I can't state you do directly, but I'll meet with your attorney. We'll start doing that in a few minutes. If you do not have an attorney, what's going to happen is either Ms. Sherry Middleton here with the blue shirt or Ms. Lenise Fletcher in the black and white striped shirt. You call your name. We call about 4 or 5 at a time. When they call your name, you're going to go out the double doors over here to my right and left. Follow them down the hallway. There's a little area outside my office. Have a seat in one of those chairs. I'll call you back one at a time for your conference. When you're done with your conference, you're going to come back to the same hallway, back to the same set of double doors. Quietly have a seat in the courtroom, either enter your plea or get instructions for your trial date. When you come back to the courtroom, make sure that you do use the double doors, not the single door there. Just Mr. Hutchinson, you do that, you'll disrupt court, make the judge unhappy. There's obviously a lot more of y'all than there are of me, but I do what I'm doing. I do this pretty much every day. I move quick. I'll have everybody out of here at a decent time today. All right, thank y'all.
Good morning. My name is Terrence Malloy, and I represent the Duke Clerk, who's in Public Defender's Office for this court. Like Mr. Shepherd said, we do this all the time, so even though I'm here by myself today, I will get you as fast as possible. What we need to do, folks, here's how this is going to go. For those of you that I've already announced for, as you can see, I've got your files right here. There's information in your files. I'll give you updates on where we are. We'll speak back to one of the jury rooms with all of your file individually and decide where we're going to go from there. After that, Well, here's what I basically need you to do. When the judge leaves the bench and takes a break, please be present when I call your name. Here's how this is gonna work. I come out and call your name. If you're not here, I'm gonna do this. See where you went? Model power. All right, so guess what it's gonna take? Me some time to get back to you. All right, so help yourself by being present. I say this every single time we have a calendar, and I can't think of many times where it hasn't happened with someone when we call their name and we're not present. Now I'll do it one time. I come back and do it a second time. That means you went from the bottom of the pile back to the top. I do it a second time, you're still not here. You're gonna have to address your honor. Everybody get that? Okay. Again, I make this announcement every time. Somebody, lo and behold, will be that one individual who wants to test that theory to see if that's gonna work. It does work. If you have to address the judge, well, I can't do much for you at that time. So help yourselves and help me help you by being present when we call your name. Some of you, I have quick resolutions for you, and I will try to get you those of you out as fast as possible. But other than that, again, just be present when we call your name. Thank you.
All right, and I know some of you are thinking, why is Mr. Malloy so frustrated with this? And the short answer is because we are. I do not know where people go. Oil changes, haircuts, I don't know. But like my instructions are really simple. You ready? Here's the instructions I'm about to give you. Go to the restroom, because we're all human, and get back to your seat. Like, it's as simple as that. Step to the restroom, back to your seat, and wait for your name to be called. Step to the restroom, back to your seat, wait. And every single court day, somebody wanders off. And so the fact that we've had to create a solution for this because somebody doesn't understand every time one person doesn't understand, step to the restroom and get back to your seats. I issue a warrant, and it's a do not reset. And I'm just going to send you out to the jail. You're going to wait out there till I go see you out at the jail on a Wednesday afternoon. Don't volunteer for that. Like, it's the most preventable bench warrant I issue. And every time I issue one, I'm like, I can't believe I'm issuing this. So there it is. Somebody statistically will volunteer to be that person today. I hope it's not any of you all. With that said, it is 9:40. I'm going to step off the bench until 10:30. So here's your instructions. Everybody ready? Step to the restroom, get back to your seat, and wait for your name to be called. If anybody has any confusion about those instructions, speak with the bailiffs. I'm sure you all will be just great, but statistically, one of you will not. All right, that's it. I'll see you all at 10:30. I'm off. Mr. Item, singing unmute request.
Yes.
Mr. Item?
Yeah.
Mr. Item, you there?
Yes. Yes, sir.
Okay. Your attorney's announced for you. My job is just to get a good phone number for us to reach you this morning. What's a good phone number?
773-757-9164.
All right, you gave me 773-757-9164.
Yes, sir.
Okay, that's all I need. You are, you may remove yourself from the video conference system, but you're not released from court. Your attorneys will call you, in just a little bit and give you an update on your case.
All right. Thank you so much.
But you can remove yourself from the virtual system.
Okay.
Just now for
And then Ms. Wright, I think, we'll talk to Mr. Page just for a moment, and then we'll take the plea. Okay. Let's start with the basics, because I think I have an idea of what's going on here. So, raise your right hand for me. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, yes, sir.
Okay. State your full name, first, middle, last, and whatever.
Benny Charles Page, Jr.
Okay. What's your birthday?
6/4/74.
And then your father would be Benny Charles Page Sr., correct?
Yes, sir.
Okay, because I have a senior in here. And then, do you have a son named Benny Charles Page?
No, sir. I'm Benny Charles. My son is Ben Quavius.
Oh,
Yes.
now I'm starting to understand this. But he's been Quavius Page.
Yes, sir.
Is his middle name Charles?
It's Charquel. It's close.
Okay. Does Benny end with a Y or an IE?
BNY.
There it is. Okay, I see where it looks like we may have gotten y'all's wires crossed in our system. Because you were saying you didn't know Mr. Moody was your attorney.
No, sir. I thought it was a blessing.
And then, well, you got that blessing for your son, I guess. Because Mr. Moody, is that correct? You're actually representing his son?
Yes, sir, we were.
Okay.
I believe that case resolved in like 21.
Oh, you need to call next week.
Well, I'm looking for Fonzo White.
He's in the hall.
He's in the hallway. Okay, thank you.
Want me to send him around?
Yeah.
Yeah.
Yeah, you don't mind, thank you.
That's the son. All right, Mr. Moody, what is your understanding of your role in all of this?
In relation to
I don't know.
Mr. Page, president.
Junior, is your father still alive?
No, sir. He passed.
I'm
3
sorry.
years ago.
I'm sorry for your loss. Versus this gentleman here versus his son.
I know we had filed an entry for his son back in 2021, but I thought that case was resolved.
Okay, the one that I was confused about is the one, this one here is 21 SR 2344 shows that y'all represent this gentleman. I was trying to see if there was something in there, but it looks to me like it might just be,
In my system, I only showed one entry for Ben Quavius Page. I don't show an entry ever being filed by us for Ben Page.
Yeah. All that people you gave him. His son, those numbers, 2344, 2343 are both on his.
Right here.
I see it there. What's the proposed solution here? I guess, Mr. Page, you're wanting time to get all this sorted out.
Yes, sir. Your Honor, can I speak, please?
Give me just 1 second, and then yes. That's what happened. Yeah, I just saw that. All right, go ahead.
Your Honor, I went to prison last year, May the 1st, and I got out May the 1st this year. And what I was saying is when I went to prison and got out, when I came to court here last week, they had put a bench warrant out on me while I was locked up. So I never got a chance to see anybody battle an attorney or nothing. When I came last time, I got locked up and put in a holding cell for bench warrant for not coming to court for this. But yes, so I haven't had a chance to even talk to an attorney about it.
All right, well, let's do this. Mr. Shepherd has the right to put a say in this. I'm gonna go ahead and say that on 21 SR 2344, that's the one that's confusion about. All I have is the motion to withdraw. I don't have an entry of appearance. I don't have anything else. It looks to me like maybe Mr. Moody's office just put the wrong case number on there and then filed it because it has this case number on it.
Okay.
And so that's what I'm gonna call it. I'm gonna call it that. The motion withdrawal, which is filed with the wrong case number. We're gonna take a moment. I'm gonna take Ms. Wright's plea when Mr. Shepherd comes back in. We'll have a quick conversation, finish this up, and we'll go from there. So, both case numbers were on there. So 21 SR 2343 was also, so both of them are on. So, okay, that's it. I'm gonna take Ms. Wright's plea and get her out of here. Mr. Moody, if you'll go tell Mr. Shepherd we're ready to hear that on him, and we'll get you both out. Sounds good.
And I have another one. I have another one signed.
Oh, you have one signed up? Okay, I'll take Ms. Wright's plea. You grab Mr. Shepherd, and then I'll take the plea.
Sounds good.
This is Yarborough.
Yes, sir.
Okay. I think you still have it. You can bring one up. Let's do it together, make sure we have it all right. Come on up. All right, let's go on record. This is Valerie Yarborough, represented by Attorney Wright. Ms. Yarborough, if you please raise your right hand for me. Do you solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You can take your hand down and state your full name for me.
Valerie Yarborough.
All right, and Ms. Yarborough, you're here on 23 SR 0582. You're entering into our accountability court program, and so what is about to happen is I'm going to enter this plea with you and your attorney's permission, but I'm not going to sentence you. I'm going to stop at the sentencing, and then you'll go complete the accountability court. You understand that?
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, so you were here on time for court this morning. Is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes, sir.
Are these your initials next to each of the lines
Yes,
on
sir.
page 1? Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
No, sir.
All right, if you think of any, you promise to ask me.
Yes, sir.
All right. Ms. Yarborough, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
And are you satisfied with the job your attorney, Ms. Wright, has done on your behalf?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes, sir.
All right, I'm gonna pivot to your attorney unless you have any questions for me about anything we've covered.
No, sir.
All right, Attorney Wright, do you stipulate that there's a sufficient factual basis, in this case for me to accept this DUI plea, from January 15th, 2023?
Yes, Your Honor, so stipulated.
All right, do you wish to enter a guilty plea to that DUI charge?
Yes.
Okay, and then, back to you, Attorney Wright, on count 2, the failure to maintain lane from the same course of events, do you stipulate to that factual basis?
Yes, Your Honor.
Ms. Yarborough, do you wish to enter a guilty plea to that charge?
Yes.
All right, I'm gonna find between the stipulations of counsel and the request to enter guilty pleas from the defendant that there's enough for me to accept the plea. I'm gonna find that she is knowingly, voluntarily, and intelligently waiving her rights in entering this plea. I've reviewed the recommendation, and if it becomes necessary, I will follow the recommendation of this court. Now, at this moment, I would normally begin sentencing, but it is my understanding, Ms. Wright, that you all have negotiated an agreement for her to enter and complete the accountability court program.
That is correct, Your Honor.
All right, so is that correct, Ms. Yarborough?
Yes, sir.
All right, and you've actually already begun the program.
Yes, sir. I have
Wonderful.
started.
We're very proud of that program.
Yes.
It's
It's a blessing.
yeah, it's one of my favorite parts of this job. So, all right, so what we're going to do then is, Attorney Wright, do you stipulate that y'all are waiving the right to withdraw this plea unless and until she completes the accountability court program successfully?
Yes, Your Honor.
Ms. Yarborough, do you stipulate and agree that you are waiving the right to withdraw this plea unless and until you complete the accountability court program?
Yes, sir.
You understand that if you fail to complete the terms of the accountability court program, you can either withdraw voluntarily or you can be withdrawn involuntarily after a hearing, at which point I would sentence you according to these terms, exactly according to these terms that are on this document.
Yes, sir.
All right, hopefully they'll never come to that, but it's my job to say awkward things like that out loud. All right, so here's how we're gonna do this. At this point, you have signed the sentencing sheet, your attorney has signed the sentencing sheet, I will not be signing it. I'm gonna pull the original off, I'm gonna attach it to the contract, which is up here with me. That is going to get filed with the clerk, and that is finished. Here's a copy for you and your attorney, to keep with you. That way, if you do ever, if there ever is a question about what the sentence would be if you had to get removed, that would be it. I'm also gonna ask my court reporter to please create a transcript of this plea, and file it with the clerk. That way there's a very clear record that you are waiving your right to withdraw this plea and what the terms are. Attorney Wright, as I told you before the plea off record, that this is a newer system that we're putting into place. Any questions, concerns, anything else that you see from your end as to how we're doing this?
No, Your Honor. Things have been pretty straightforward and.
Okay, good. Ms. Yarborough, anything else?
No.
Okay. Ms. Yarborough, at this point, what I'm gonna do is, when's your next check-in with Ms. Heffron?
Well, probably tomorrow
Okay,
because I checked in last night, so
yes.
I'm
You're doing it, just.
doing it consistently like they asked me, so.
Well, Ms. Yarborough, there's always a transition period in getting into accountability court. It's a very intensive program, but it's also provides you an extraordinarily high level of support.
Right,
Um,
definitely.
And so I just want you to know that, you know, there's always some bumps as you get adjusted. So
Yeah,
you just keep at it, okay?
yes, sir.
All right, do y'all need anything else?
I think that's it.
All right, well, since I haven't sentenced, we're not gonna do habeas and all that. I'm just gonna say I look forward to seeing you standing with Judge Essery with that dismissal in hand about 18 months or so from now.
Yes.
Okay?
Yes, sir.
All
Thank
right.
you.
And that's it, we're adjourned.
Thank you, Your Honor.
Thank you, Ms.
That's all the business that I have to report. May I be
That
excused?
sounds great. Thank you.
Thank you.
Let's come back to order. We're going to finish up Mr. Page's matter with Mr. Moody. Both of y'all come up, please. Mr. Shepherd is now present, as Mr. Shepherd requested the opportunity to speak into this. And I'll just say out loud, I spoke with the attorneys prior to coming back on the record where I filled Mr. Shepherd in on what we did here before.
Yes, sir.
And let him know that Mr. Moody did not represent you, that it was simply a case number error where Mr. Moody's office filed a motion to withdraw in a case that he was not the attorney of record on. So, and as you said, Mr. Page, he was not you didn't know anything about him until you walked in this morning.
Yes, sir.
All right. Did you want to tell me anything else, Mr. Page, before I hear from Mr. Shepherd and Mr. Moody and then make my decision?
Well, no, sir. I just thought this morning about not having an attorney. I just thought this was where I came and applied for an attorney, but.
Okay. And we'll cover it. We'll cross that bridge here in just a minute.
Okay.
All right, Mr. Moody, anything else before I make my decision? Mr. Shepherd, you wish to speak into this?
Yes, Judge. So we're opposing the continuance in this. These arrests are, one of them's from February of 2020, the other one's from June of 2020. So he's had over 3 years now to hire an attorney if he wants to represent him on this. He's known these cases were pending for over 3 years. He's got 65 cycles on his criminal history. That's when we ran it in 2020. So I would imagine he's fairly well acquainted with the process of getting an attorney. With that many cycles on his criminal history, it's not his first time through the system. He knows how to get an attorney. He knows how to apply for a public defender. It's time to go on these. These are old cases. He's been aware of them. We just oppose any continuance because we need to get these things resolved.
Okay. Now give me 1 second. I have a procedural question. Okay. Mr. Moody, your homework when you leave here is your office needs to file a withdrawal of the withdrawal. Because otherwise I have to issue an order and I'm not going to issue an order on this, but I need to close that in my system.
Yes.
Okay. So file that notice of withdrawal of your motion and you're free to go.
Thank you,
So I'll finish this. I'll do your plea on the other one, Overton, and then we'll go from there. Mr. Page, I'm looking at the file here, your actual file that's actually yours. And I have a question for you. It looks to me like you signed a reset notice on July 10th. Is that correct?
Yes, that's, I'm saying when I didn't even know nothing about this. When I came to court to plead, that's when I had a bench warrant for not coming to court on this case. But, Your Honor, I was in prison.
Yes, sir.
And, you know, even though the charges are 3 years old, I haven't even received a notification. You know, most people don't get an attorney until they receive a court notification.
Okay. So I put a document up on the screen there, Mr. Page. It's got your 2 case numbers on here. Is this your signature?
Yes, I never got out since then.
Okay.
Yes, sir.
Okay, but I need you to answer the questions I'm
Yes, sir.
asking, and then I'll answer the questions you're asking. Is that your signature?
Yes, sir.
And is that your handwriting dating this document 8/10 of 22?
Yeah. Yes, sir, it is.
Are these your initials?
Yes, sir.
And this bottom one says, it is my responsibility to hire an attorney or apply for the public defender's office ASAP. The public defender's office is located at 126 North Hill Street, and now they're at 435 South Hill Street. Griffin, Georgia 30223. Is that correct?
Yes, sir.
And that's your address?
Yes, sir.
Okay, and then that brought you were supposed to be here on November 7th of 2022.
Sir, I never got out of prison. I never was notified. The prison didn't even get a court date and say, well, Benny, you have a court date. So a bench warrant was taken out on me November 2022, and I was in prison. I didn't get out till May the 1st. And when I came out May the 1st, that's when I came to court for this, and I was taken downstairs for a bench warrant.
Okay.
So Well, it was 5 years, I never got notification to now.
All right,
Yes,
and then
sir.
I have this other document here. Is that your signature as well?
Yes, sir.
And it's the same document dated 7/10/23.
Yes, sir.
All right, when did you ever go to 126 North Hill Street and see about retaining or applying for the public defender's office?
Sir, I never got out since then. I'm saying after I got locked up in May, I'm saying after I got out in May.
Right, so you've been free since May?
Yes.
Okay. All right, that'll work. All right, anything else you want me to know, Mr. Page?
Well, sir, I just asked for a chance to get my attorney or whatever.
All right, well, your request for a continuance is denied. This is a long calendar, I got plenty of time. You're not waiving the right to have an attorney. You can certainly hire Mr. Moody or some other attorney. But the fact is that despite what you're saying, we're just gonna have to agree to disagree. My position is that you were notified on August 10th, when you signed this document, that it is your responsibility to take action. You could certainly have mailed a letter to them. You could certainly have taken all kinds of action. You've been out since, I don't know who's talking out there, but stop. You've been out since May. In July, you didn't take any action. In July, we specifically brought to your attention that you needed to take action ASAP. And you said you've been out since May. So the short answer is you're stuck with me. So I'm sorry, Mr. Page, but your charges are very old. And I will also say that at the time you originally arrested, you would have been given an application for the public defender's office there as well. So you didn't walk in here this morning thinking you had Mr. Moody. You didn't know this was happening until here, according to the testimony that's been given. And obviously that was just a confusion all around. So, okay, that's the decision of the court. You're stuck with me. Grab a seat. I'm gonna come back and talk to you just a little bit more about what's next. Okay? All right, Overton. I don't have her information sheet, but that's okay. All right, raise your right hand for me. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down and state your full name for me.
Carrie B. Overton.
Ms. Overton, you're here on 22 SR 0810. On this case, you were on time for court. No, that's right. You were in the wrong courtroom at the right time. Is that the one?
Yes.
You called your attorney to the wrong courtroom.
Yes, sir.
Got it, okay. Your attorney has passed up to me, we're gonna skip that part. We're going forward to this document here. Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes.
page 2?
Yes.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it?
Yes.
And because you understood everything that's on it?
Yes, sir.
All right, Ms. Overton, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes.
Are you satisfied with the job Mr. Moody's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
All right, Ms. Overton, do you have any other questions for me about anything we've covered so far before I pivot to Mr. Moody with my next set of questions?
No, sir.
Mr. Moody, do you stipulate that there's a sufficient factual basis for me to accept this shoplifting plea from May 26th of 2021?
We do, Your Honor.
And Ms. Overton, do you want to enter a guilty plea to that charge?
Yes, sir.
All right, I'm gonna find that between Mr. Moody's stipulations as factual basis and Ms. Overton's request to enter a guilty plea, there's enough for me to take the plea. I'm gonna find that she's knowingly, voluntarily, and intelligently waiving her rights to entering this plea. I reviewed the recommendation, I'll call it. Anything to add for our sentence?
Yeah, just in the way of why this recommendation looks a little atypical. All of the merchandise was returned, or she actually never got outside of the store with it. In addition to that, Miss Overton's been seeking treatment. This was a result of underlying drug issue, and she has been seeking treatment on that regard. And, in talking to Mr. Shepherd, he was satisfied with that, knowing that she's still under supervision.
And that's, you said the Fayette County?
Yes.
Okay. All right. Well, given that she's being supervised in Fayette County, I think that's appropriate. And yes, the sentence is odd, but I will follow it.
Thank you, Judge.
All right, Ms. Overton, you ready for me to sentence?
Yes, sir.
All right, here we go. Ms. Overton, on 22 SR 0810 from May 26th of 2021, shoplifting, I'm gonna find you guilty. It's 12 months probation, $590 is your fine. You may work your fine off with community service work at a rate of $10 per hour. There will be a $25 intake fee added to your case. Get your valid license or show a valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. $50 per month supervision fee. Do not go anywhere near any Walmart, and your case will close the moment you've satisfied your obligations to the court. You said it was Fayette County.
Yeah, she's in doing the drug court treatment. But, you know, essentially, just a pay and no additional supervision.
Oh, I know that. I'm just simply noting here, so 5 years from now, if we look at this and go, why in the world did he do a terminate immediate? I'm gonna put in Fayette County Accountability Court. You notice it doesn't say complete, it just says in. So that way there's just a record of why this sentence is as wonky as it is.
Yes.
I don't know, I don't have and yeah, so she'll need to fill out that information sheet back with probation. You have 30 days from today if you want to appeal this decision. You have 12 months from today if you want to use your habeas rights. Mr. Moody can explain all that if you have any questions. That's all I have. So, all right, thank you. If you'll walk back down, Bale's gonna have to fill out your paperwork. All right, Mr. Moody, you're free to go.
Thank you, Judge.
And make sure you file the notice of withdrawal of that motion.
Yes, sir.
All right, I gotta step off the bench for about 10 minutes. When I come back out, I'll take the pleas that are ready.
Excuse me, Judge, can I approach?
Yes. She needs to go. She needs to go. Because she doesn't have probation. It's terminated upon completion of probation. So she needs to go back and get probation. So I'll tell her. Ms. Overton.
Yes, sir.
It's not that you don't have probation. It's terminated upon completion probation. You're on probation with me. Now, the fact that you may complete those tasks quickly and get your case closed would be congratulations, but you're on probation and you need to go meet with the probation officer. Now, you're wanting to get these things done quickly so that you can be released, which it seems to me like you're gonna be able to do.
Yes, sir. I was just confused. I was just told.
It's okay. That's why I brought you back up, so that I can very clearly
Yes,
and
sir.
gently and firmly say,
So,
you need to go meet with your probation officer.
yes, sir. Okay.
They'll tell you how to get it closed, and they'll tell you how to get it closed quickly.
Yes, sir.
All right, go head out those double doors, please. I've got to go to this 11 o'clock. I'll be back. We're in recess for about 20 minutes.
Pro se's done. I got things to look at.
All right, I'm gonna start doing the pleas. I'm gonna start with the self-representatives. And then as soon as the clerk cleaner's office is ready, we'll go with those. I need Fonzo White to step forward, please. All right, Mr. White, please step up to the podium there. And raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. White, you were on time for court, but you were unable to be in the courtroom this morning. Is that correct?
Yes, sir.
All right, so what I'm gonna do is I'm gonna jump forward to this document right here, which is this self-represented defendant plea rights waiver.
Okay.
Do you recognize this document?
Oh, yes, sir.
Are those your initials next to each of the lines on page 1,
Yes, sir.
page 2,
Yes, sir.
and is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Are there any questions, Mr. White, that I can answer for you about anything on this document?
No, sir.
Did you see on here where it says you have the right to have an attorney represent you,
Yes, sir.
and you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
All right, Mr. White, do you have any other questions for me before I pivot to the facts of your case?
No, sir.
All right, Mr. White, you're charged with one count of theft by deception in that you did, here in Spalding County, back on September 7th, 2021, you did provide looks like a phone to Echo ATM that was not yours by falsely creating the impression you were the owner, which you were not, and which you knew you were not. Is that correct?
Yes, sir.
All right, I'm gonna find with your admission of guilt as to theft by deception that there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation and I'll follow it. Any questions about anything before I sentence?
No, sir.
All right, you ready?
Yes, sir.
Here we go. Fonzo White on 22 SR 0736 from September 7th of 2021. I'm going to find you guilty of theft by deception. It's 12 months of probation, a fine of $445 as your fine. Showing valid license to probation, no alcohol, illegal drugs, or hemp products, and a Fourth Amendment waiver for searches by law enforcement and probation. $50 supervision fee per month, $25 intake fee, one time. You can work off your fine with community service work at $10 an hour, $55 in restitution to Echo ATM. Okay, so you're gonna be my very first new, so we just put in on Friday a new way to do probation restitution, so follow me to the end of what I'm about to say. So here's how this is gonna work. The $55 to Echo ATM, you're gonna make that as a one-time payment in full to the clerk within 6 months. Now, your responsibility is to provide the receipt that you will get from the clerk's office to probation within 6 months. If you do not provide that receipt to probation within 6 months, or of course communicate about any concerns or questions you may have, they will file a motion to revoke your probation. Do you understand that?
Yes, sir.
So that receipt must be provided to the Spalding County State's Enforcement Office within 6 months.
Can I ask you a question, sir?
Yes,
So the clerk's office is in this courthouse?
yes, downstairs, first floor.
Okay.
So, and again, you can't make partial payments. It's gotta be one payment of $55 to the clerk. And once you've made that payment, you take the receipt to probation. The receipt to probation is what clears you of any trouble with probation. Does that make sense? So, in other words, like if you don't pay it within 6 months and you don't do the receipt within 6 months, probation has no way of knowing whether you paid it or not. So The key to that is take the receipt you get from the clerk's office. You know, the probation office is only a block and a half, so you can easily walk from one to the other without taking too much extra time.
Okay.
Okay, like I said, you're my first one of that. We had to change that last week unexpectedly, and that's the system we came up with. Okay, your probation will close the moment you've satisfied your obligations to the court. You have 30 days from today. If you wish to appeal this decision, you have 12 months from today if you want to use your habeas rights. And of course, you could pay the restitution earlier. You just can't pay it later than 6 months. Any questions?
No, sir.
All right. Then I'm going to pass you over to the bailiffs. You're going to walk out those double doors, and good luck to you.
How good?
Thank you. All right. Wait. Am I correct?
Is ours.
The story is yours.
Story and Boyd.
Oh, they're both yours.
That's when I put it together, Judge.
Oh, that makes sense. Okay, actually, wait, Mr. Malloy's gonna be out in just a second. So. Actually, everybody else is yours. I'm gonna announce the null process then. I gotta start it. All right, null process as we go. All right, first null process is Bernie, B-I-R-N-E-Y. Third item down. All right, that goes to Eric. All right, next null process is Bud, bottom of page 1. Once lifted, I guess. All right, next case is Helms. Top of page 3. Next null process is Betty Payton, bottom of page 5. Next null process is Ward, middle of page 7. All right, is there anybody who came in late? Anybody come in late? All right, what's your name?
Sade.
Come on up. All right, what's your name?
Sade Lane,
Spell your last name for me.
L-A-Y-N-E.
Okay. Ms. Lane, you are represented by Mr. Malloy, the Public Defender's Office. They've already notified me that you were here. Has Mr. Malloy spoken with you yet?
No.
He'll be calling your name here in just a little bit, so.
Okay.
You can have a seat. Anybody else? All right, that's good, so that takes care of. Mr. Page, come on back up. Okay. Mr. Page, do you understand that today is the 14th and that trials do not start for 2 weeks from today? Do you understand that?
Yes, sir.
And so, do you want to, you have a couple of options, same as just before, which is that you can have me just put your case down for trial. You can have a conference with the solicitor's office if you want. And you have not, again, you've not waived the right to have an attorney. You've simply, I just simply have said that you've waived the right to have a public defender's office because all the stuff you put earlier. So do you want to talk to the solicitor's office? Do you want to go see about hiring an attorney? Or do you want to just have me put you down for trial?
You can put me down for trial. That's enough time for me to have an attorney.
Okay. All right. Well, then what I'm going to do is you have two, and you understand that if you don't have an attorney, you'll be representing yourself?
Yes, sir.
All right. Well, then what I'm going to do is I've got two verdict forms for you to sign, one for each of your two cases.
Yes, sir.
And you have a felony upstairs. Let me look at that one. 23R299. Oh, we got a conflict on that one. They've got their calendar call scheduled for August 28th, which is the day you're supposed to be with me for my jury trial. So we'll have to sort that out with Judge Sams. That you have two different courts you're supposed to be in on Monday. My jury trial versus their calendar call. And I'm going to order you to come to me first because I'm the jury trial.
Yes, sir.
And I'll communicate with Judge Sams. And you need to communicate with your felony. You have the felony public defender's office on that case.
Yes, sir. I'm aware of that, sir.
So you did get that application.
Well, my wife, she did it while I was locked up because she claimed, well, you know, it's a different story. But
Yeah, we're okay.
Yes, sir.
Okay. Do you, and if you get an attorney, tell them they need to reach out very quickly to the solicitor's office in the court and let us know that they're in, okay?
Yes, sir.
All right, I'm printing your verdict forms now.
Yes, sir. Thank you.
All right, Mr. Page, I've printed both of your verdict forms. I've attached copies of the accusations to it. Again, you may seek private counsel, but you'll need to be here on the 28th down here with me. We'll make certain to communicate with Superior Court that I brought you to me first. Since I'm the jury trial, I get dibs. And that way they won't issue a warrant for you upstairs.
Yes, sir.
So come here first, and then we'll communicate with them to get you where you need to go.
Yes, sir.
All right, I'll see you back here on the 28th. And like I said, you've already got counsel on the felony, so you don't have to take any action on that, other than you need to check in with them and let them know about the conflict.
Yes, sir.
All right.
Thank you, Your Honor.
You're free to go. I'll see you back here on the 28th.
Okay. Let's go back to it.
All right. We are off record until Mr. Malloy finishes his last conference, and then we'll take his place. All right, we're gonna start with LeCompte. Mr. LeCompte, if you'll please step forward to the podium. All right, please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, take your hand down and state your full name.
Jeremy LeCompte.
All right, and Mr. LeCompte, you are on time for court this morning, is that correct?
Yes.
All right, and Mr. LeCompte, did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. LeCompte, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are those your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And to ask your attorney, Mr. Malloy, and now Mr. Charles next to you, any questions you may have about it?
No, sir.
Yes?
Yes, sir.
All right, and because you understood everything that's on it.
Yes, sir.
Any questions I can answer for you about anything on this document?
No, sir.
All right. Do you understand that have you had all the time that you need to ask your attorneys all of your questions about all aspects of your case?
Yes.
Are you satisfied with the job they've done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes.
All right. Any questions for me about anything before I pivot to your attorney?
No, sir.
Mr. Charles, do you stipulate on this case, 22 SR 0371 from June 14th of 2020, that there's a sufficient factual basis for me to accept this false name charge?
Yes, I do, Your Honor.
All right. Mr. LeCompte, on all false name and date of birth charges, I do two things. Number one, I want you to tell me your full name, first, middle, last, and anything after that.
Jeremy Armand LeCompte, and my birthday is October the 3rd, 2001.
Okay, perfect. And do you want to enter a guilty plea to this false name charge?
Guilty.
All right, I'm gonna find with Mr. Charles's stipulations as the factual basis combined with your request to enter the guilty plea, that there's enough for me to take the plea. I'm gonna find that you are knowingly, voluntarily, and intelligently waiving your rights to entering this plea. I reviewed the recommendation and I'll follow it. Any questions? Mr. Charles, anything you wish to add?
No, Your Honor.
All right, Mr. LeCompte, any questions before I sentence?
No, sir.
You ready?
Yes.
All right. Jeremy LeCompte, 22 SR 0371 from June 14th of 2020. False name, guilty. 12 months of probation, $280 is your fine. Count 2 will be dismissed. Show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. $50 supervision fee per month. A one-time $25 payment as an intake fee to probation. You'll be supervised by Spalding County Sentence Enforcement. $50 in public defender restitution, and your case will close the moment you satisfied your obligations to the court.
Okay.
You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. You remember me talking about habeas earlier?
Yes.
You remember reading about it on the back of the right sheet right there.
Yes, sir.
All right, any questions for me?
I have a question. On all the cases, Mr. Shepherd said he want to access 20 hours community service.
Oh, yeah, he did say that.
Yes. So it's 20 hours community service.
They're supposed to be.
Yes.
Yeah.
Can you put it on the record?
Yeah, that's supposed to be on there. Glad we caught that now. That would have been messed later. Okay, 20 hours. Mr. LeCompte, I understand your child is sick. Is that correct?
Yes.
All right. I hope whatever's happening, everything's going to be okay for you.
Okay, thank you, sir.
Thank you. You may go out those double doors. They'll get you out of here. Tell them that your son's sick. Is it your son or your daughter?
My son.
Your son. Tell them your son is sick, and they'll get you on out the door.
Okay.
All right. Emery, come on out. All right. Please raise your right hand for me. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down, state your full name for me.
Richie H. Emery.
All right, Mr. Emery, you're here on 22 SR 0698, and it's my understanding that you are on time for court. Is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint I put up on the wall?
I did.
Did you understand those rights?
Yes, sir.
Do you, are there any questions I can answer for you about anything on those rights?
No, sir.
Mr. Emery, your attorney has passed up to me this attorney independent plea rights waiver that I'm holding up. Do you recognize this document?
I do.
Are those your initials next to each of the
They
lines on page 1?
They are.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And having an opportunity to ask your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes, sir.
Are you satisfied with the job they've done on your behalf?
I am.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
You have any questions for me about this document, this attorney defendant plea rights waiver, or anything else before I pivot to your attorney?
No, sir.
Mr. Emery Mr. Charles, do you stipulate that there's a sufficient factual basis on 22 SR 0698 from June 22nd of 2020 for this theft by receiving charge?
Yes, I do, Your Honor.
And Mr. Emery, do you wish to enter a guilty plea to that charge?
Yes, sir.
All right, I'm gonna find between Mr. Charles' stipulations and Mr. Emery's request to enter a guilty plea that there's enough for me to take the plea. I'm gonna find that Mr. Emery is knowingly, voluntarily, and intelligently waiving his rights to enter the plea. I reviewed the recommendation and I'll follow it. Mr. Charles, anything you wish to add before I sentence?
No, Your Honor.
Mr. Emery, any questions before I sentence?
No, sir.
All right, here we go. Richie Emery from 22 SR 0698 from June 22nd of 2020. I'm gonna find you guilty of theft by receiving. It's 12 months of probation, no fine. Show your valid license to probation, no alcohol, illegal drugs, or hemp products. You'll be tested for those. Fourth Amendment waiver, $50 per month supervision fee, a one-time $25 intake fee will be paid. In addition, you'll also have a one-time restitution payment of $50 to Spalding County to offset the cost of your attorney. You will also pay $500 in restitution to Clinton Jones. And here's how this is gonna work. We just rolled this out. You heard me do that other plea earlier, correct?
Yes, sir.
All right, so you have 6 months from today to pay the $500 as a one-time payment in full to the clerk of court. You must provide that receipt to your probation officer within 6 months. They provide that receipt to probation, or of course work with them if you need additional something or other, will result in a revocation hearing. Do you understand that?
Yes, sir.
All right. So do not make a partial payment to the clerk. They will not accept it. They're under orders to refuse partial payments. Okay. All right. So that's the instructions. 20 hours of community service work and your case will close the moment you've satisfied your obligations to the court. All right. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. You remember reading about habeas right there?
Yes, sir.
On the back of the right sheet. Anything else you need from me before we part ways?
No, it was explained to me that, upon completion of the restitution, that the probation was over with.
It's terminated upon completion. So the moment, it's not just the restitution, but the moment you've checked your boxes, your case will close.
No,
You're only on probation until you've satisfied your obligations.
so,
Until you pay the fine and you do a community service.
can I pay it?
Your supervision fee.
I mean, in supervision.
Yeah, so the probation will go over your to-do list to get your case closed, but you hold the closure in your hand. If you have everything ready now, you could close it
Today?
theoretically today. But you gotta go meet with probation and they'll give you the to-do list. But, you know, they don't wanna keep you on probation any longer than you wanna be on it, so that's up to you. All right, does that answer your questions? All right, thank you.
I don't know if it was Mr. Boyd, is that older road truck driver?
This is,
Okay.
this is, anyway,
Oh, okay. I'm ahead of myself then.
you're
All right,
moving
step
fast.
Okay, okay. I'm sorry.
You're moving fast, that's okay. All right, Willis? I can't remember those either. You're Tanya Willis?
Yes.
All right, please raise your right hand for me. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, take your hand down and state your full name for me.
Tanya Willis.
Ms. Willis, you're here on 22 SR 400. Am I correct that you are on time for court today?
Yes.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights?
No.
Ms. Willis, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes.
Are those your initials next to each of the
Yes.
lines on page 1?
Yes.
Page 2?
Yes.
Is this your signature?
Yes.
Did you sign and initial this document after having all the time you needed to review it
Yes.
and to ask your attorney any questions you have about it,
Yes.
and because you understood everything that's on it?
Yes.
Have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes.
Are you satisfied with the job they've done on your behalf?
Yes.
You understand that you have the right to a jury trial,
Yes.
and that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes.
All right, any questions for me about this or anything else before I pivot to your attorney with my next set of questions?
No.
Mr. Charles, do you stipulate that there's a sufficient factual basis for me to accept this plea on 22 SR 400?
Yes, I do, Your Honor.
Okay, and I was trying to find the incident date, but it's eluding me at this moment. Okay, so, Ms. Willis, do you wish to enter a guilty plea to this disorderly conduct?
February 11, 2021.
Say it again?
February 11, 2021.
All right, 2/11/21. All right, on February 11th, 21. Do you want to enter a guilty plea to that charge, Ms. Willis?
Yes.
All right. I'm going to find with Mr. Charles's stipulations, combined with Ms. Willis's request to enter a guilty plea to disorderly conduct, there's enough for me to find her guilty on 22 SR 400 from February 11th of 2021. As to disorderly conduct, find her guilty. It's 12 months probation. $445 is her fine. You can work your fine off with community service work, show your valid license to probation, no illegal drugs, hemp products, or alcohol. You'll be tested for those. $50 per month supervision fee, $25 intake fee, $50 is a one-time payment to Spalding County for restitution to offset the cost of your attorney. You're going to do 20 hours of community service work, and your case will close once 3 months have passed, no violations have occurred, and all conditions have been met. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you remember reading about habeas on the back of the right sheet where I'm pointing right there?
Yes.
All right, do you need anything else from me, Ms. Willis, before you and I part ways?
No.
All right, Mr. Richards will walk you out the double doors there. Thank you. All right, I'm going to do the last two, please. I think they're coded for minutes.
Yes.
Do you have Stephanie Johnson?
Oh, yeah,
We
actually,
have Stephanie Johnson.
no, I'm going to pass that. So Johnson. All right, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down and state your full name for me.
Stephanie Danielle Johnson.
All right, Ms. Johnson, you're here on 22 SR 1781. Ms. Johnson, according to my memories, you are on time for court, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are those your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
And is that your signature there?
Yes, sir.
Did you sign and initial this document after reviewing it fully with your attorney?
Yes, sir.
Because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes, sir.
Are you satisfied with the job they've done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
All right, any other questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Charles, do you stipulate on this case, 22 SR 1781 from July 4th of 2022, that there's a sufficient factual basis for me to take this reckless driving plea?
Yes, I do, Your Honor.
Do you want to enter a guilty plea to that charge?
Yes, sir.
And then Mr. Charles, count 3, the duty to report an accident. You stipulate on that one as well.
Yes, I do, Your Honor.
And do you want to enter a guilty plea now to count 3, the duty to report an accident?
Yes, sir.
We'll find with Mr. Charles' stipulations combined with Ms. Johnson's request to enter guilty pleas that there's enough for me to take the plea. I'm going to find that Ms. Johnson is knowingly, voluntarily, and intelligently waiving her rights and entering this plea. I reviewed the recommendation and I will follow it. Mr. Charles, anything you wish to add?
No, Your Honor, thank you.
Ms. Johnson, any questions about anything before I sentence?
No, sir.
You ready?
Yes, sir.
Okay. Stephanie Johnson, 22 SR 0781 from July 4th of 2022. Count 1, reckless driving. I'm going to find you guilty. It's 12 months probation, $1,222 is your fine. Count 3, duty to report an accident. Guilty, 12 months. Concurrent, $300 is your fine. Counts 2 and 4 will be dismissed. Show your valid license to probation. 2 weeks supervised by the Spalding County Sentence Enforcement. No alcohol, illegal drugs, or hemp products should be tested for those. $15 per month supervision fee, $25 one-time intake fee, $50 one-time public defender fee as restitution to offset the cost of your attorney. You're to complete 40 hours of community service work at a rate of no less than 6 hours per week. Substance abuse evaluation shall be completed within 90 days. And DUI school shall be completed within 60 days. You have 30 days from today if you wish to appeal this decision. And you have 6 months from today if you wish to use your habeas rights. Do you remember reading about habeas in the back of the right sheet, right there where I'm pointing?
Yes, sir.
And are there any questions I can answer for you in any way before you and I part ways?
I do have one.
Okay.
Oh, Your Honor, she's talking about her license. What's it taken?
They were supposedly suspended, and they're currently suspended now.
Because of this?
Yes.
This is going to clear that up. So you'll take this. We will send it into GDS within 48 hours. That will trigger the release. You can also take a copy of that down there to VDS to also see about getting it released. So you should, unless there's something else, this in and of itself, this will fix this in and of itself. If you have something else, I can't help you.
Okay.
But if I remember when I spoke to you, didn't you tell me your license was suspended in Henry County?
They were suspended in Spalding for this incident, but when I got pulled over in Henry County, I didn't know they were suspended. I still had a valid driver's license to show the police officer and everything, and that's when they came back and told me my license was suspended.
Okay, I see. So you have suspended license charges in Henry County?
No, it happened here. They took my license here. I didn't know about any of it from the incident of July 4th.
Okay.
I didn't know about it, and then when I got pulled over in Henry County, they told me my license was suspended and did not know.
Okay, that makes sense. So this will fix that.
Just
So
ALS off of this case.
this all makes sense and you're gonna be okay.
Okay.
All right, Boyd and Story, since they're co-defendants, I think they're co
I'd say that's okay.
Okay, and I'm gonna do their pleas together unless y'all want me to do them separate.
No, we can do it.
Yeah, she's just gonna get it.
I see Miss Story. Miss Story wasn't
All right, and while Ms. Story's coming in, I believe Mr. Boyd's truck driver.
Yes, sir.
All right. And I assume you need some flexibility in reporting.
Yes, sir, it'd be greatly appreciated.
You're not my first truck driver, it's okay. Okay. All right, that is a beautiful baby. So, all right, you are, Nalai?
Nala?
Nala, Story?
Yes, sir.
All right, and you're Mr. Boyd?
Yes, sir.
And y'all are co-defendants, correct?
Yes, sir.
All right, neither of you have to raise your right hands because you're holding the baby. Just, do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? And the way we'll always do it is Ms. Story will answer first, Ms. Boyd will answer second. Will you do that?
Yes, sir.
Will you do that?
Yes, sir.
All right, you're both under oath. Mr. Story and Mr. Boyd, y'all are, both were on time for court today, but I think you were outside in the hallway because of the baby. Mr. Boyd, you heard the rights I read out to the courtroom, is that correct?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
All right, to you, Ms. Story, your attorneys have passed to me this attorney and defendant plea rights waiver, and Mr. Boyd, I'm holding yours up as well. Ms. Story, do you recognize this document?
Yes, sir.
All right, Mr. Boyd?
Yes, sir.
Are these your initials, ma'am, next to each of the lines on page 1?
Yes, sir.
Mr. Boyd?
Yes, sir.
Are these your initials, ma'am, as to count on page 2?
Yes, sir.
Mr. Boyd?
Yes, sir.
All right, and is this your signature, Ms. Story?
Yes, sir.
And Mr. Boyd?
Yes, sir.
All right, and for the record, I'm holding them up as I'm going through them. Ms. Story, have you had all the time, did you sign and initial this document because you understood after having all the time that you needed to go through it?
Yes, sir.
Mr. Boyd, same question?
Yes, sir.
Ms. Story, did you have an opportunity to ask your attorney any questions you have about it?
Yes, sir.
Mr. Boyd?
Yes, sir.
All right, and Ms. Story, did you understand everything that's on it?
Yes, sir.
Mr. Boyd?
Yes, sir.
All right. Are there any questions? Well, let's just jump forward. Ms. Story, have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes, sir.
Mr. Boyd?
Yes, sir.
Do you understand now that you have the right to a jury trial?
Yes, sir.
Yes, sir.
And by entering this plea, that you're giving up that right to a jury trial?
Yes, sir.
Yes, sir.
All right. Any questions I can answer for you, no matter how large or small, about anything on this document?
No, sir.
No, sir.
All right. Ms. Story, do you have any questions for me before I pivot to your attorney with my next set of questions?
No, sir.
No, sir.
All right. Ms. Story, starting on 22 SR 0683, and then Mr. Boyd, your case is 22 SR 0662, with the same incident date of July 7th, 2020, because you're co-defendants. Mr. Charles, do you stipulate that there's a sufficient factual basis for me to accept this plea on the joint charge of cruelty to animals?
Yes, I do, Your Honor.
Ms. Story, do you wish to enter a guilty plea to that charge?
Yes, sir.
All right, Mr. Boyd, do you wish to enter a guilty plea to that charge?
Yes.
All right, I'm going to find with Mr. Charles' stipulations as to the joint charge of cruelty to animals across both of them, with both of their requests to enter the guilty plea, that there's enough for me to take a plea. I'm going to find that Ms. Story and Mr. Boyd are both knowingly, voluntarily, and intelligently waiving their rights and entering these pleas. I reviewed the recommendation, and I will be following the recommendation as it has been negotiated. Mr. Charles, is there anything, we talked about the truck driver situation. I already have a solution to that. He's not our first truck driver, so we know how to handle that. Do you have anything else you wish to address with me?
No, Your Honor.
Okay. Ms. Story, do you have any questions for me about anything before I sentence?
No, sir.
Mr. Boyd, do you have any questions for me before I sentence?
No, sir.
Okay, then here we go. Ms. Story, starting with you, on 22 SR 0683 from July 7th of 2020, cruelty to animals, I'm going to find you guilty. It's 12 months probation, $590 is your fine. You may work off your fine with community service work, show your valid license to probation, no alcohol, illegal drugs, or hemp products, $50 per month supervision fee, one-time $25 intake fee, payment to probation. You'll be supervised by Spalding County Sentence Enforcement. You will be doing 20 hours of community service work. And once 6 months have passed, no violations have occurred, and all conditions have been met, I will allow you to go to non-report probation. During the entire period of 12 months, you shall not possess pets or any other animals.
Sir,
Yes, ma'am.
they said that I wouldn't have to go community service.
Oh, was that specifically waived in your case?
She done,
I think because she had 3 children and she doesn't have any babysitters. So I think that was the issue.
Okay.
When we discussed it in the office, Your Honor.
All right, as long as it was discussed and intentionally not there, that's fine.
It was discussed in our office. I don't know what Mr.
We discussed
Lloyd
it that day.
and
They just.
Well, it's on Mr. Boyd's, that's fine.
yeah, we go from there.
All right, Ms. Story, that's your plea. Mr. Boyd, you have, on 22 SR 0662, count 1, cruelty to animals, guilty, 12 months, $590 is your fine. Again, you've worked your fine off with community service work, show valid license to probation, no alcohol, illegal drugs, or hemp products. $50 per month supervision fee, a one-time payment of $25 as an intake fee on this case. 20 hours community service work. Now, here's how reporting is going to work for you. Oh, and of course, do not possess pets or other animals. And once 6 months have passed, no violations have occurred and all conditions have been met, your case will go to non-report. Now, for the truck driver part, that's easy. Here's how we're going to do this. You will provide your schedule to probation. So I'm going to put that your schedule to the Spalding County Sentence Enforcement, and then I'll put your be on phone report when deployed. Fair enough?
yes, sir. Also the, community service part.
Yes, sir.
Your Honor, it was agreed to there will be no community service because he's going to pay the fine. instanter on that.
Okay, that sounds fine. Like I said, as long as that's part of the intention negotiations,
Yes,
it's
sir.
2 thumbs up for me.
And I've got another one, Judge, well, that was the same thing, Mr. Emery, so.
Oh, I gotta fix that one then?
Yes, sir.
Okay, happy to do it. Okay, so that's removed. And that'll take care of the truck driving part. You've got this other case, 0663, that is in Alcross. I'm signing that now. That closes out that case, that goes there. And, all right, either of you have any questions for me, starting with Ms. Story before I?
No, sir.
Okay. All right, thank you.
Yeah, on Ms. Story's case, community service on there, was it?
It was like I said,
Okay.
I put it on there out of habit, and then as soon as y'all pointed it out, I took it back off.
Okay.
So,
Okay.
yeah, I just simply said, I just wanted it to be an intentional decision, and Mr. Charles said he was pretty confident it was an intentional.
It was, yeah, that was part of the negotiation with the state.
All I'm looking for is intentionality.
And the same
Y'all
thing
go with Mr. Hadaway.
with Mr. Emery, that was part of the negotiation there.
Where's the,
Restitution.
where's the original?
It may be back there with probation.
Emery's original? I need the original, I need the,
Okay, it may be back there with probation, yeah.
Miss Ellis, Officer Ellis, we have it. Oh, I have another null process, Sanford. Bobby Sanford. All right, we're off record. What else do y'all have? Is that everything for y'all?
For now, I guess.
I think,
I think he has the last two.
yeah, we have 2 late folks come in that he was talking to. All right.
Mr. Bynes, on calendar, Your Honor, is charged with the DUI. The issue with Mr. Bynes is, Your Honor, when I was back to talking with him, trying to see if he'd be able to go through the plea, he has some memory issues, and when answering my questions, I wasn't comfortable with even trying to set him up for a plea, Judge. I spoke with Mr. Shepard about it. He's like saying, this case has been around for a while. This is a DUI. He's had DUIs in the past. So we're now deferring to the court on how the court wants to handle this case. I'm of the opinion right now that I don't think he can successfully get through a plea, to be honest with you. You can ask him whatever questions you want, Judge, but.
If we did it as a plea in absentia, where it was all in writing, again, I'm just throwing an idea.
Yes, sir.
So, that, where it's all there and he can review it as often as he needs to before he signs it. And obviously, we don't do this right now. We
Yes, sir.
give y'all a little bit of time. But,
Yes, sir.
he could come back and I could simply ask him, very simply put, this is a plea in absentia. I normally do it when you're not here.
I just wanted for the court to understand what the concerns are. Again, we think he may be in the early stages of maybe Alzheimer's or dementia, but he has not been diagnosed yet because a lot of things have happened. He just recently lost his caretakers who were his parents, but now he's got these folks here on the front row who aren't technically or biologically family, but still people who want to support him.
Sure.
But so none of them can really do that kind of thing. So that's why we're asking the court for some direction today on how to handle this particular case. Because again, Judge, I don't think we can go through a plea, and I don't even think we, so that's what I just wanted to.
Okay. Let's do this. So let's punt for today. Let's have him walk in next Thursday. That'll give us time to figure out options before. That way we're not stuck in on Monday with the trial, trying to figure out if we have jurors, witnesses, or a plea.
The reason why I turned around to see the people that may be assisting him if they were available. I know the one lady said she wouldn't be available.
Does
on
next Thursday work for y'all?
I can do it.
Okay.
Okay.
Perfect. So we have a yes from the crowd. Okay, and that'll give us time for us to talk.
Yes, sir.
And again, y'all know, I'm very grateful to y'all when y'all step into these difficult situations. I'm very flexible in coming up with a solution here. So let's just talk in the next couple of days. Whatever we come up with, we'll figure it out.
Yes, sir.
Yeah, let's get my gears turning. So we'll figure out something.
So
Next Thursday.
This week, the 24th.
I'm grabbing my calendar.
You finished?
I think Marty's probably gonna file some stuff. You talking about the 24th?
Well, we.
Yeah, so 24th.
August 24th, not this coming week Thursday,
Right.
but next Thursday, a week from Thursday.
9 a.m.
Yes, sir. Would that be okay? August 24th. Okay.
And that gives us a week and a half to come up with some creative solutions.
Okay. So that was that one, Judge. Okay, you're gonna have a seat. Mr. Starger?
Feel free to go now.
Yes, now.
Yeah, feel free to go now.
Mr. Starger's on the calendar, Judge. I think he may have come in late, but his situation, he's got 2 cases on the calendar, and I was just informed by the state he has a 3rd case. And he had indicated to me on the stalking case, I don't remember the case number on there, but the one that's on the calendar for stalking, that he wanted to go to trial.
Okay.
All I was attempting to do was getting him to sign the jury demand form for the cases, and basically I was gonna keep them all 3 together. He's got some contention with that, saying he didn't want to sign the form to keep the cases together.
Okay. Mr. Starger, what is your wish on the stalking case? Do you want to go to trial or do you want to see about resolving it?
I would go to trial on the stalking case, but before that goes, she informed me that she spoke with either you or somebody already, but so
Are you feeling okay? You
I
seem
am.
off to me.
No, I'm a little like, cause I don't know what he's saying. He told me that we gotta go. I'm going to trial for all the cases. I'm like, I don't want to go to trial for all the cases. I want to try to resolve a couple of the cases that he said. I said I would go to trial for the stalking charge.
Okay. Have you had anything to?
I have to take 5 drugs, things a month. I don't do nothing. I'm in grip already. So no, I don't do no drugs.
Just
nothing.
you're swaying a bit, your eyes are glassy.
Maybe
you're
my
slurring
blood
your
pressure,
words.
maybe. I do got high cholesterol, all that type of stuff, but maybe that, but other than that, no. Unless you want to test.
I'm certainly thinking about it.
Well, you can have it. I
So
definitely
you
gotta go
passed
take
a,
another
did
one
a breath
today.
test now, you passed one?
A breath test?
Yeah.
Definitely. I don't drink anyway, period.
And you take medicine that's making you, you're saying you take medicine that's giving you
I
this?
just take cholesterol medicine.
Okay. All right, I'm not
Which
splitting
I
your
haven't
cases
had.
up, so you can deal with all of them however they go. The 3rd case, which I think an accusation was filed this morning. Do we have a case number on that?
They've not yet.
That's what I'm saying.
Who's this?
Mr. Stargell, I'm concerned he might be
last
intoxicated. He says he's not, but I'm
We
going
can
to
figure
take
that out real quick.
Do what?
Did we find that out real
Well,
quick?
he's saying it might be medicine or it might be something
We
else.
definitely can figure it out real quick.
Well,
I
y'all
don't
see if
drink.
Alice has a breathalyzer back in her office. I don't know if she does.
We filed the accusation July 28th.
On the new case?
Yes, sir. It's a fleeing marijuana and obstruction.
All right, what's that case number?
23 SR 1091.
Okay, so Mr. Stargell, here's how this is gonna work. Well, I'm also worrying about whether or not you're intoxicated or not, because it's my obligation to find out if you're intoxicated. Because if you are, I can't do anything with your cases today. On 22 SR 0342, 22 SR 1892, I'm adding to this calendar effective immediately 23 SR 1091. I have more than 10 days from trial, so I'm adding this. I'm pleading you not guilty, so today's officially your arraignment date, and I'm adding this to the trial calendar. I'm gonna have you come have a seat in the jury box over here while I figure out whether or not you are intoxicated. And again, I've already stated on the record that you're slurring your speech, your eyes are watery, you're unsteady on your feet, and I have all of it. Those are all the indications I need that you may be intoxicated. Okay, with that, we're off record until Mr. Lloyd tells me he has the next step ready.
I got a book at because she's claiming somebody's using her ID.
All right, Ms. Keaton, if you'll please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. If you will lean into that microphone, state your full name for me, please.
Shinkway beyond the age of Keaton.
All right. And Ms. Keaton, you are here today on 22 SR 1104 for a theft by deception. It's my understanding that you wish to have a jury trial on that charge. Is that correct?
Yes.
Ms. Keaton, I do not show you as having an attorney. Am I correct that you're representing yourself?
No, I'm gonna hire one.
Okay. Do you understand that as of this moment, you don't have an attorney, and so I'm moving forward as if you don't? Do you understand that?
That's fine.
Okay. And so that means that the document you're about to sign, should you choose to, is going to indicate that you're waiving the right to have an attorney. Do you understand that? But you're not. You're not waiving the right to have an attorney altogether. You may certainly go hire an attorney, but if you come back on the 28th and you don't have an attorney, I will be expecting you to represent yourself. Do you understand that?
Yeah.
Okay.
Yes.
Is that lineup acceptable to you?
Yes.
Okay. Now, whichever attorney you retain to represent you on this, ma'am, you make certain to tell them that you're on the calendar for the 28th, and Judge Thacker says that a continuance is highly, highly unlikely, that we're ready for trial. So whoever you retain to represent you needs to come ready for trial, okay?
Okay.
If you, the last day I anticipate accepting any plea on anything to do with this calendar will be Thursday, the 24th at that calendar. So if you and your attorney work out an agreement for you to take a plea, you'll need to walk in on the 24th to work to get your case resolved. Do you understand that the 24th is the last time I anticipate taking pleas on this calendar?
Yeah.
Okay. Do you have any questions about anything that I can answer for you, ma'am?
No.
Okay. All right. Then that's it. Go, like I said, you said you're gonna go hire an attorney, go do that. And just know that the 24th is your hard stop for resolving this case without a trial. And not an
Bring any police reports you have on that.
Okay, that's it.
On the oath.
To order, everybody, we have Miss Lane, who was late. Miss Lane, raise your right hand for me. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. Miss Lane, please state your full name for me.
Sade Shanti Lane.
All right, Miss Lane, you're here on 22 SR 0923. You're late to court, which means you missed the rights I read out and put the PowerPoint up on the wall. Is that correct?
Yes.
I'm holding up this attorney and defendant plea rights waiver. Do you recognize this document?
Yes.
Are those your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
And is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it
Yes.
and asking your attorney any questions you have about it?
Yes.
And because you understood everything that's on it?
Yes.
Ms. Lane, have you had all the time that you need to speak with your attorneys about all aspects of your cases?
Yes.
Are you satisfied with the job they've done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial in this case, will be closed. Is that what you want to do?
Yes.
Ms. Lane, do you have any other questions for me about anything on this attorney and defendant plea rights waiver or anything else before I pivot to your attorney with my next set of questions?
No.
Mr. Malloy, do you stipulate that there's a sufficient factual basis for me to accept this plea on 22 SR 923 from March 26th of 2022 for disorderly conduct?
Yes, Your Honor.
Ms. Lane, is that what you want to enter a guilty plea to?
Yes.
Okay. Ms. Lane, as to 22 SR 923 from March 26th of 2022, I'm going to find that you're knowingly, with your request to enter the plea combined with Mr. Malloy's stipulation of factual basis, there's enough for me to take the plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I'll review the recommendation and I'll follow it. Anything you wish to add?
No, Your Honor, thank you.
All right. Any questions about anything, ma'am?
No.
All right. You ready?
Yes.
All right. Ms. Lane, on count 1, disorderly conduct, I'm going to find you guilty. It's 12 months probation, $590 is your fine. That's a total of 12 months probation. Show you valid license to probation, no alcohol, illegal drugs, or hemp products. You can be tested for those. $50 per month supervision fee, a one-time payment of $25 as a probation intake fee. You'll be supervised by Spalding County Sentence Enforcement. $50 one-time payment restitution for your attorney. 20 hours of community service work. No violent contact with Cassie Lavelle. And your case will close the moment you satisfy your obligations to the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you want to use your habeas rights. Remember reading about habeas on the back of the right sheet right there?
Yes.
Now, do you have any questions for me about anything before you and I part ways?
No.
All right, then I'm going to pass you over here to Mr. Taylor. He's going to walk out those double doors, and good luck to you, ma'am. All right, I'm printing Mr. Stargill's paperwork. Very nice, Jackie. How you doing?
You made up for all the weeks in town.
I never feel.
Yes. All right, that's the last one.
Okay.
She was the walk-in. She was not on the camera.
Yes, this was.
Yes.
Your Honor.
Yes.
Ready?
All right. Your last name is Larry?
Yeah.
All right. Please raise your right hand for me. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Take your hand down. State your full name for me.
Marvista Larry.
All right. And that's M-A.
RVISTA.
Got it. And then your case is 22 SR 0563. And it's my understanding that you were, although you're not on this calendar, you were on time this morning. Is that correct?
Yes.
All right, so, actually, record. Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
I didn't, but it was relayed to me.
That's all right, I've got it here as well. So this is the written version of those rights.
Oh, okay.
Do you recognize this attorney defendant plea rights waiver?
I do.
Are these your initials next to each of the lines on page 1?
It is.
Page 2?
It is.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
I did.
And to ask your attorney any questions that you have about it?
Yes, sir.
And because you understood everything that's on it?
I did.
Have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes, I did.
Are you satisfied with the job they've done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes.
All right. Do you have any other questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right. Mr. Malloy, on 22 SRO 563 from June 5th of 2020, do you stipulate there's a sufficient factual basis for me to accept this battery family violence plea?
Yes, Your Honor.
Do you wish to enter a guilty plea to that charge?
Yes, sir.
Do you, Mr. Malloy, back to you, do you stipulate as to count 2, the cruelty to children and the third-degree charge?
Yes, Your Honor.
Do you wish to enter a guilty plea to that cruelty to children charge, ma'am?
Yes.
All right. Ms. Larry, I'm required to tell you that by entering this plea, it's a family violence plea, which means you'll lose your rights to possess firearms and ammunition for the rest of your days. Do you understand that?
Yes, I do.
Is that okay with you?
Yeah, I mean, yeah, I guess. Yeah.
Well, it's by operation of law, so I just want to make certain that you're aware of it and that you understand that that is simply what's going to happen next.
Yes, I'm aware.
Okay. All right, and you're okay with me going forward with your plea?
Yes, sir.
All right, then, all right, well, then I'm gonna find with Mr. Malloy's stipulations, the factual basis combined with, Ms. Larry's request to enter guilty pleas on the 2 charges, that there's enough for me to take the plea. I'm gonna find that she's knowingly, voluntarily, and intelligently waiving her rights and entering this plea. I reviewed the recommendation and I'll follow it. Anything you wish to add?
Just one thing, Miss Larry no longer lives here in Spalding County in Griffin, Your Honor. She now lives in Atlanta, so she would need phone reporting. She asked about being able to community service. I said she could do that up there too, so.
Absolutely.
They will work with her on working that out.
And I've just marked phone report, so it's actually technically electronic report now. They've got more, this new system they have has the ability to do electronic report with email and all that, so it's a lot better system. So it's gonna give you a lot more options. It's better for you, so.
Okay.
It's not just phone now. I'm excited about that. All right, then, anything else?
No, Your Honor.
All right, you ready? Do you have any questions?
I don't. No, I'm ready.
All right. All right, then, Ms. Larry, on 22 SR 0563 from June 5th of 2020, count 1, battery under the Family Violence Act, I'm gonna find you guilty. It's 12 months probation, $685 is your fine. Count 2, cruelty to children in the 3rd degree, guilty, 12 months consecutive, $685 is your fine. That's 24 total months of probation. Counts 3, 4, and 5 are dismissed. Show your valid license to probation of alcohol, illegal drugs, or hemp products. You be tested for those. 4th Amendment waiver, $50 per month supervision fee, a one-time $25 payment to probation as an intake fee, and a one-time $50 payment to offset the cost of your attorney. 20 hours of community service work, which you can do at any approved location, which up in Atlanta, there's a billion of you. You won't have any trouble finding a place up there. No violent contact whatsoever with Reginald Wooten.
There's a long list, Judge.
Yeah, there's a long list.
How about this? There's a long list of folks on this page that you've signed. Do not have violent contact with the folks in the first list or violent contact with the folks in the second list. All right, you have 30 days from today if you wish to appeal this decision. Oh, you can be a phone report or electronic report is what they want me to call it now. All right, that's it. You have signed the notice that you understand that you may no longer possess firearms and ammunition. I'm signing that saying that we reviewed it in open court during the plea. And you have 30 days from today if you wish to appeal this decision. You have 12 months from today if you want to use your habeas rights. Remember reading about habeas right there. All right, do you need anything from me, ma'am, before you and I part ways?
I do not.
Okay. Then I'm going to pass you off to Mr. Williams. He's going to walk you out those double doors and meet with probation. Okay, we're back on record with Mr. Stargill. For the record, Mr. Stargill volunteered to do sobriety testing when I was asking him about whether or not he was intoxicated. So Griffin Police Officer came in, did the testing, has cleared Mr. Stargill, saying he's not intoxicated. So Mr. Stargill, I don't know, like I said, I'm still seeing what I'm seeing, but I trust him.
I've always talked like that. I got a cracked second longboard disc. That's why I keep switching that feet.
Okay. Well, you're clear by my book, so here's what we're gonna do. I am preparing right now 3 jury trial notices. And I'm gonna have you sign each of them, saying that this is what you wanna do.
So is that my only right to go to trial on all cases? That ain't what I agreed to.
Okay, what is it you want to do that I'm not understanding?
My only choice with my lawyer, I suppose, what I had back there, either tell him something now or go to trial on all 3 cases. He asked me, what you gonna do about the stalking? I said, we can go to trial on the stalking case. He said, well, we going to trial on all 3 cases. I said, that ain't what I'm saying.
Well, he's simply
I don't have no other options pertaining to, for as his concern is, but go to trial on all 3. And I know,
well, Mr.
I'm
Malloy,
sure I got more rights than this.
Mr. Malloy is simply repeating to you what I'm saying.
What are you saying?
I'm saying I'm not going to separate out these 3 cases.
I'm not saying separate. I'm saying I'm not willing to go to trial on all 3 cases. I know I got a little more right than just go to trial on all 3 cases, since there is some other options.
Yeah,
like it's never said, okay, now we might can go first offender on this, or we might can do a no-no on this. We can do something on other than go to trial on all 3 cases. That ain't what I said.
Okay. Well, your options are, it's really straightforward, okay? So I know what you think you should have the right to do, but I need you to stop
Okay.
telling me what you
I just
think.
wanna know what
I
the
need you
rights
to
are.
stop interrupting me. I was right in the middle of a sentence, okay? So deep breath, and we're gonna do this right, we're gonna do this on the record, okay? I need you to understand what you think you have the right to, and what I'm about to do are two different things. Do you understand that?
I don't even understand the statement you just made. You said what I think I got the right to do
Yeah.
and what you gonna do.
That's right.
So I just wanna know what the rights are.
Okay, you have the right to a jury trial. I'm gonna schedule all three of these for trial on the 28th. Are you gonna be willing to sign the verdict form saying that you're ready for trial or not?
On the stalking, yes, sir.
Okay, well, let's start there. Mr. Malloy, since that one is not an issue, I'm gonna pass that one to you while I prepare the other two. We'll go ahead and sign that one.
And the third one, the last one, he just said you could pass that one too. I'm willing to go to trial on that one also.
The marijuana case or the driving case?
What driving case? I was only called over here today for 2 cases. Then I get back there, yeah, they added the third one. So
I'm they. There's no mysterious they in this
Because
courtroom.
when I called, they said you on the docket for 2 cases.
Well, let's just be really clear. There's no mysterious they who's pulling the strings behind this thing. It's me.
For 9 o'clock this morning, I was on the docket.
This is why we're having an issue, because every time I open my mouth, you start talking over me. Which gives me another indicator that I think you're intoxicated on something that doesn't show up on a breath test, because you have an inability to let me finish a sentence without telling me what you think I need to hear. I do not have to let you walk out of this courtroom. I am not required to accept that officer's findings that you are not intoxicated. Because just because you tested negative on a breath test doesn't mean you don't have some. If you're about to interrupt me, don't even think about it. Do you understand how hard you have to push on me to get me to lose my temper? Do you understand how few people have seen this in a courtroom? Probably 2 hands, 2 fingers, 20 people in 6 years. Congratulations. You're going to trial on your 3 cases. I don't care what you think you should or shouldn't be able to do. The jury will have 2 options. They will either see that form that you've signed, or they will see it where it says that you refuse to sign it. Those are your only 2 options. Do you understand that your only 2 options at this moment are to sign the form acknowledging the jury trial, or refuse to sign it and have the jury see that you refuse to sign it? Do you understand that?
I do.
Here you go, Mr. Moore. If you wish to enter a non-negotiated plea where I choose the sentence on all 3 cases, that is your only other option. But we are not doing it today. If you want to enter a non-negotiated plea and close all 3 of your cases without a trial, you may walk in on the 24th of August and enter that non-negotiated plea. But that is your only other option other than trial. I am concluding this matter. I do not intend to hear anything else from you. Sign them, don't sign them, I don't care. Otherwise, I'll see you back here on the 28th at 9 a.m. sharp. If you want to resolve your cases, walk in on the 24th at 9 a.m. sharp. Once you've signed those documents, you're free to go. This matter is concluded. Mr. Shepard, is there anything else we need to address?